Is that yours?
Is this yours?
Yeah.
Okay.
I'm all too. Thanks.
Good morning.
Good morning. Glenn Carter on behalf of this.
Justice Thomas and the plaintiff, Brian Cortland.
So there are three motions today. One is a motion to continue or amend the schedule for this matter moving forward, and that appears to be agreed. Is that accurate?
That's correct.
So I'll grant that request and sign an order consistent with that request, if either party has a form of order consistent with that. The second is the motion for reconsideration, which I am going to grant at least in part, but I do not want or need to hear argument on it. I'm going to further consult those resources and references cited in the briefs from both parties, which I found to be helpful and clear. The one I wanted to address at the outset was that it was not the court's intent in its order to suggest that Lewis County had altered its structure in an effort to shield records from the Public Records Act, but rather that was a legal hypothetical indicating that this isn't something someone could do and thus the law is this way. I will at least amend my order to make it clear that the court was not casting judgment on any untoward motives by Lewis County in that regard. I'm withholding statement regarding anything else, so unless and until something else gets changed in that order, and I'm not saying that I will at this juncture, that means that the motion to compel is ripe for the court's consideration, and that's what I want to hear argument on today, particularly what exactly, precisely, is being sought through a motion to compel at this juncture. And I believe, given it is your motion, Mr. Thomas, it's most appropriate for you to hear from you first, and specifically walking through which discovery requests, what they ask for, and why you think they're still relevant, and then we'll have the customary back and forth.
If I may, Your Honor, I'm going to start a little bit out of order with the motion to compel. I'm going to start with a reply by Lewis County, and I'm not sure how this was presented to the county clerk or how this was presented to the court in the judge's copies. However, and I'm holding up the reply to the motion to compel that plaintiff received. It has red markings or red ink all throughout it. And this is a violation of GR 14. GR 14 clearly states that there shall be no colored markings in motions or pleadings.
And so I'll indicate that for this particular one, given the timing that I was reviewing, I looked in Odyssey, and color doesn't transport into Odyssey. So maybe the judge's bench copy, which I'm grateful are provided, in this particular instance I didn't see because I was looking on the electronic version. I'm unaware of that. So I don't know how it ended up occurring in that respect.
Okay, we would still ask that this is a violation of GR 14 and this entire reply is stricken, or this entire response is stricken from the record because it violates GR 14.
And I will deny that request, and I will hear the motion and response on the merits.
Okay, so on the merits of the motion, on May 5th, 2017, this court ordered from the bench, or made a ruling from the bench, for plaintiffs in order to work with defendants in order to receive all records responsive to Mr. Cortland's 16 public records request because this court found a violation of the Public Records Act. As indicated in my CR 26I declaration, defense counsel and I have gone back and forth in email and on telephone on all the issues presented in the motion to compel. Defendants claim that they tried to cast a wide net regarding Mr. Cortland's public records request, but that's not true. We went through several emails and we went through a telephone call, and they still managed to withhold 634 documents before this hearing today. It was filed after the motion, these documents were provided after the motion to compel was filed, after all of the CR 26I conferences were performed, but before this hearing. Mr. Carter is wearing two hats today. Mr. Carter is wearing a hat of defense attorney, which is completely appropriate in our opinion. But he's also wearing the hat of the public records officer. He is the one certifying which documents are produced according to this court's May 5th, 2017 request. And he is acting as a public records officer under RCW 42-56-580 and ensuring that he's the point of contact between the plaintiff and Lewis County in providing these records pursuant to this court's ruling from the bench on May 5th, and making sure that all the relevant documents are produced, such as a public records officer would do. However, a public records officer is inherently neutral. A public records officer doesn't have any skin in the game. A public records officer is supposed to, according to RCW 42-56-580, Section 1, to oversee the agency compliance with the Public Records Act, as well as to serve as a point of contact with the public. That means that they're supposed to be independent and they're supposed to be objective. Mr. Carter cannot be both. He cannot be an advocate for one side and be biased, just like I'm biased in this proceeding. I'm an advocate for one side in this adversarial proceeding. But he also can't try to be an objective party, which is a public records officer. There is no proof in the record whatsoever that any public records officer from Lewis County, there's evidence in the record that there are public records officers in Lewis County, has performed even a search for these records. So there's a serious question to this court about whether an adequate search for all documents responsive to Mr. Cortland's 16 public records requests were made pursuant to the Public Records Act. There's policy reasons why we have a public records officer, so that they know where these documents are. They're familiar with the agency. That's why they're appointed by the agency, so that they know where the documents are in the agency, know where to look in order to perform an adequate search, and that they also know the law. They're required to undergo training pursuant to RCW 42-56-152. They're required to undergo training in order to know the law about public records. And just being an attorney doesn't make you qualified in order to be a public records officer. So there's serious questions about the adequate search. Mr. Cortland, in the motion to compel, identified 25 potential documents or 25 potential instances of where an adequate search may not have been done. There has been nothing to rebut that. There have been no declarations, no affidavits, no certifications by defendants saying that they performed an adequate search. Neighborhood Alliance, which is the seminal case on this in the Public Records Act, states that in order to overcome that presumption, agencies must have some sort of evidence, some sort of affidavit, some sort of declaration in order to prove that they made an adequate search. That hasn't been done here. So what we have here, Your Honor, is we have an unauthorized public records officer acting as a public records officer pursuant to this court's May 5th, 2017 ruling from the bench. And then we don't have any certifications that an adequate search was performed. And on the eve of this hearing, we have 634 documents just magically appear.
When did you receive those documents?
I received them on Tuesday, which would be the 11th.
So have you had sufficient time to review those documents to see how, if at all, they affect your request for relief in a motion to compel?
I have looked over the documents. I've performed a perfunctory overview of the documents, and from my, at least, quick look at them, they appear to look at the administration, management, and the operation of the Law Library Board, and so I believe that there are potential records in there. I do not know for sure if there are responsive records in there.
So at this point, given the timing of that production, which I know is not ideal, given that a motion to compel had already been filed, is it fair to say that we aren't really in a position to identify yet what needs to be compelled additionally because of the late production of those documents?
I would agree with that, Your Honor. We don't know. There are some things that we do know that do need to be compelled, but we do not know everything that needs to be compelled. I think that would be plaintiff's stance. For example, in response to Mr. Cortland's 9th and 10th public records requests, he asked for any documents that identify filing fees. from the district court and from the superior court. I have gone back and forth with Mr. Carter about this, and Mr. Cortland believes that all filing fee documents, even if they don't break out the $17 for this paid to the Law Library Board out of every case, because the statutory language says it's mandatory that money be taken out of the $240 filing fee, that will indicate how many filing fees were paid. I don't know if I was articulate with that.
I understand what you said.
Thank you. So there are cases like that we believe that we have identified documents that are responsive to his request that have not been produced. And so we don't know the full scale of this yet, but we are trying to dig deeper.
Anything else to add?
Yes, let me go to the interrogatories real quick. The interrogatories are very important in this case, Your Honor, because if Lewis County, Mr. Cortland asked whether or not Lewis County can identify in the plain language of the statute in two of these interrogatories, in interrogatory 4 and interrogatory 8, whether Lewis County can identify in the plain meaning of the statute where it gives them legal authority in order to do what they do. If they can't find any plain language in the statute to authorize what they did legally, that means they acted in bad faith. They had no legal justification to do this whatsoever. This goes to the penalty hearing, and this goes to the Yusufian factors, and this is necessary that Mr. Cortland receives answers on this, because as the Washington Supreme Court said in the Yusufian case, that the Yusufian factors provide guidance to trial courts and to appellate courts as to how to apply the penalty. And this goes to bad faith, whether Lewis County was actually adhering to the law, whether they believed they were adhering to the law, or whether they did not believe they were adhering to the law. Lewis County made sham objections. They said this was attorney-client privilege. There's no legal justification saying that the plain language of the law or identifying the plain language of the law or providing a statutory interpretation of the law is attorney-client privilege or work product. These are evasive answers, and these are just meant to avoid answering these questions, because this could prove bad faith. Furthermore, on interrogatory number 9, although this doesn't ask the plain language of the statute, it asks a very simple question: the day, month, and year that the Law Library Board shut down. It ceased functioning, which was brought up in the answer and has been a central issue to this entire case. The Law Library Board shut down. We have this kind of concept from Lewis County. And I forget when I made this argument in front of Your Honor, but I told you, I've told Your Honor that I believe at one point that the Law Library Board didn't completely shut down. And we're starting to see more and more evidence of this. We identified an email from Court Administrator Susie Parker to the Honorable Judge James Lawler of the Lewis County Superior Court, welcoming Mr. Paul Dugas to the Lewis County Law Library Board on August 19, 2010, when Lewis County said in their interrogatory and when they said in their answer that it somehow just magically stopped functioning in 2010. And so what we have here is that we have a document showing that 2/3 of the way through the year, they added a new law library member in accordance with RCW 2724020, Section 2, which is the statute describing what is mandated by state law for the Law Library Board of Trustees in order to have. And they were in full compliance according to that email. It actually lists the members in that email of the Law Library Board, and they're in compliance. It actually lists the county commissioner, it lists the Honorable Judge James Lawler of the Lewis County Superior Court, and it lists three private members. And so they're at least not being forthcoming with their answer, and they're saying sometime in 2010, when we discovered documents after this court's May 5th ruling, that there's a lot more specificity that could be given to this answer at the very least. And so we believe that this answer is invasive, it's a non-answer, and that should at least be the basis in order to award the motion to compel today. Thank you.
Thank you. Mr. Carter, I'll allow you an opportunity to respond. Before you do so, I want to tell you where I think I'm headed already to see, so you can have some charted path to respond to. At this juncture, I'm inclined to, given the timing of that production earlier this week, and council's acknowledgement, which seems appropriate in my own experience, that it's tough with that timing to fully suss out and determine whether or not there are remaining documents that need to be produced, and if there are, to the extent to which there are still documents. So what I'm first going to be interested in hearing is whether or not, Mr. Carter, you anticipate that there are going to be additional productions that will be occurring, or if this is it. And then after that, I'm inclined to deny the motion to compel today without prejudice, so that Mr. Thomas can have an opportunity to determine the sufficiency of what's been produced today, and or set a date certain for Lewis County to finish its production so that Mr. Thomas can know the universe he's working with to determine its sufficiency, and then entertain a renewed motion to compel, if appropriate. In that motion to compel, the court would direct that there are specific subheadings for each discovery request that is the motion to compel is related to, that includes the language of the request, the language of the objection and written response, a description of what's been produced in response, and then the legal argument regarding why the motion to compel should be granted. That form of that motion would be of most usefulness to the court given the posture of this case. Also, I don't see the relevance in this, at this moment for this procedural vehicle, Mr. Carter, of allegations of wearing inappropriately two hats. I understand what Mr. Thomas is saying. I understand the abstract. There could or could not be an issue with that. Don't feel compelled for the court's benefit to respond to that, although I understand at times counsel, for their own sake, want to put something in the record, and you may do so. So that's my guidance for you, Mr. Carter, right now. I'm curious as to your thoughts.
Your Honor, thank you. I'm sorry you're not very loud today. Your Honor, I don't anticipate there will be any further documents. I apologize that that group of documents was inadvertently withheld, omitted. I didn't withhold it. I just omitted to produce it. I didn't know that I had done that. And when I got the motion to compel, I recognized our error and produced it. I would like, given the circumstances, I produced it without date stamping. I want to go back and print all of those out, put date stamp on them, just because it'll help all of us.
How long do you think that would take?
You know, I doubt that it would take longer than a week. And if I can do that, that will mean that we have a record with numbers on it that will make it easier for all of us later. Your Honor, I know that it has, and I won't go into this, but just for his assurance, 2 public records officers conducted the search to find the documents. The public records officer for the Superior Court and the public records officer for the prosecuting attorney's office. I did not do that. The records were collected by those PROs. I provided the certification in the way in which I thought you would do it under discovery. I provided supplemental discovery responses certifying that. Your Honor, there's lots more I could say, but I don't want to press your time. Have I answered your question?
I believe so. And so I've given Mr. Carter an opportunity to respond. You get the final word if you have anything else you'd like to add, Mr. Thomas. At this point, what I'd be inclined to do is I do believe it's helpful in these cases to have Bates stamping with the assurance that no new documents will be placed in there. In the meantime, Mr. Thomas will have those documents to review for sufficiency's sake, within the next week having the benefit of numbers to identify them in future court proceedings. And so I'd be inclined to give Mr. Carter a week for the Bates stamping. And then when Mr. Thomas is ready to file a renewed motion to compel And I understand that there's been a motion to compel filed earlier, then some things came in later, and there was a renote of the original motion. I would ask that a separate new motion conforming to the form that I identified a few minutes ago be filed, as it will be much cleaner for the record, both before this court and on appeal if necessary. So, Mr. Thomas, it's your last word because it's your motion.
Your Honor, if I may, this case has been going on almost a year, and my client's indigent. My client is living in poverty, and this is straining his resources to keep filing motions to continue. And I understand that, and I admit that I don't know all the documents that Mr. Carter provided, and I appreciate his assistance and his cooperation. However, there are some issues that I believe that the court can rule on today, such as the sufficiency of the answers to the interrogatories, and for instance, the filing fees, which I do not believe were part of the 634 documents that were provided to us. And so if we could have a ruling on those issues, I think that would even be helpful at this point.
I'm going to reserve a ruling on those issues. I understand the desire. Also, the determination of fees on a motion to compel, if any, such that it might assist with an indigent client, I would not be making that determination today in any event until after the whole circumstances of the discovery issues are before me. And so that would, even if I had ruled on the interrogatories, I would not be making a determination on fees today. Is there anything else you want to address at this juncture?
No, I just wanted to clarify that I wasn't necessarily saying about the money for him, but just every time we have to come back in the court, that it's a waste of resources.
I entirely understand. I am sensitive to that. I also am interested in making sure that we minimize for court efficiency's sake as well, and because it's in the public interest to make sure these cases are resolved in an expedited fashion. I don't believe that the way the court is handling this today will implicate the new dates that have been suggested and now ordered for the penalty phase. Is that accurate, Mr. Thomas?
I do not believe so at this point.
And so, and that is the end game that I am attempting to keep my eye on, and making sure that we manage this litigation to get it done. And so, is there an order that I can sign consistent with the motion to continue?
Your Honor, the motion to continue, I don't have that, Your Honor. Do you?
I believe that I filed a proposed order with the motion to continue, and I can write another one up and submit it to Mr. Carter, and if we agree, we can, because we both seem to agree on the
Your Honor,
substance.
if we could draft one, that would probably be best.
And you could do that before you leave today, and the clerk has blank forms of orders. You could write in those new dates, indicating the old dates are stricken, and then writing in the new dates. And you can leave that with the clerk, and he can get it to me to make sure that I can sign it.
Your Honor, I do have a simple order on the motion to compel.
And I've signed that order, and I will aspire in very short order to get the motion, the order on the motion for reconsideration done. At this point, though, parties should operate under the assumption that there has been a violation determined. Any other clarification regarding anything at this juncture today?
Your Honor, not from me.
No, Your Honor, thank you.
Thank you very much. The court is in recess. Have a good, oh, I'm sorry. Court is in recess, but I can take an ex parte matter if necessary. Have a good weekend.
Did you want to file?
Oh, I'm sorry, I apologize, yes.
You didn't file. That's okay, you can do it. Thank you.
Yes, that's Brian Green. Yeah, Brian
No,
Green.
not Brian Green.
Oh, no. Brian Cortland.